Yes,
Yes,
sir.
sir.
Yes, sir.
Yes,
Okay.
sir.
So today topic is Bharatiya Nyaya Sanhita, that is BNS or IPC, okay, Indian Penal Code. So in 2024 AIBE 19, see the weightage of the subject is 8 marks. Out of this 8, 6 are from BNS, 2 are from IPC. Okay. And all questions are from BEAR Acts only. Okay, so in IPC, there are 2 types of questions they will ask from BEAR Act. One is direct section based, and there is second thing is illustration based. Okay, there are a lot of illustrations are there in IPC. So you will get at least 1 or 2 questions from illustrations also. So it will be easy once you understand the, see, you should understand that is the reason, if you remember, couple of days back, I have given you a PDF. I shared couple of PDFs, right? Chapter wise PDF. So what IPC, BNS chapters I have given. Okay. So what crime is included under which chapter? That is very important. Okay. So
Good evening, sir.
Yeah.
So small doubt, sir.
Yeah.
Sir, is the paper will be given in regional languages also in Telugu?
Yes. When you are applying, you can opt it. Apply just after opt చేసుకుంటే వస్తుంది.
Okay, Telugu also.
Yes.
Telugu or Hindi, regional language also they will allow.
Yes, you can opt it.
Okay, thank you.
Okay. So IPC is organized. See, when you are talking about, there are 3 new acts: Bharatiya Nyaya Sanhita, Bharatiya Sakshya Adhiniyam, Bharatiya CRPC, that is BNSS. Okay, BNSS and CRPC are structure is almost similar. Minor change will be there in the sections. Okay, Evidence Act and Bharatiya Sakshya Adhiniyam BSA almost they run similarly. But IPC and Bharatiya Nyaya Sanhita is the only thing where a lot of changes happened. From IPC, there are a lot of changes in the structure of the entire act itself. So the some acts have come before, some acts have come later. So IPC was organized in one way, BNS is organized in different way. So chapter wise, IPC and BNS will look different. Say, let us say there are certain acts. In IPC, the act will be say 120, 130, but in BNS, it will be say 5, 7, 10, 12, something like that. Okay. Because what happened in BNS, so some acts, chapter they have bought before. Some chapter they have moved it to the back one. Say, let us say section, let us take 100 section. So 100 section of IPC is 38 in BNS. And there, see, there are certain definitions. Okay. So definitions, normally they are given under section 2. Okay. Section, normally in most of the acts, it is under section 2 are definitions. So in Bharatiya Nyaya Sanhita, all sections, definitions are under section 2 only. But in IPC, it is not under section 2. It is 3, 4, 5, 6, 7, 8, 9, 10, 11, 15, 20, 30, whatever it is. It goes on up to, say, almost 30, 40 sections. Okay, I think it goes up to 52, 53 sections, almost 52, 53 sections are there. That's definition sections goes out in IPC. So straight away that 50 sections are removed in BNS. Okay, so all these things are section 2, 1, 2, 2, 2, 3, 2, 4, 2, 5, 2, 6. So they keep on going that way. Okay, that is one major difference. And there is separate chapters in IPC. I mean, new chapters are in BNS. The other advantage, see, when you buy 25 book sets of BEAR Acts, you will get BNS and IPC, both books you get. So in BNS, there is a comparative chart. Okay, BNS, there is a comparative chart is there. So comparative table, you can see, you can go to some act, you can check IPC to BNS comparative chart is there. So it will be easy. Even if you study BNS properly, you can go and look into IPC and look for that particular section. What section? So that immediately you can go and open IPC and answer that. Okay. So IPC, there are more sections earlier. BNS, they have reduced the sections. So BNS, the sections is, last section is 358 sections are there in BNS. Okay. Whereas in IPC, there are 511 sections. Okay. So sections are also reduced because definitions around 40-50 sections are gone and lot of old sections are removed. So that way, sections from 500 and change odd 511 sections, they have brought down in around almost 150, 160 sections are reduced in 150 sections are reduced in BNS. Okay, that is another major change. And I have given the changes. What are the changes in IPC and BNS content also have given, because that is concept-based questions. They may ask, what is the new punishment when in BNS, which is not there in IPC. Only one punishment is there extra, that is social service or community service, whatever it is, that extra that is there. All other things are similar. Okay, so community services in BNS or IPC, they may ask you something like that. Okay, just giving an example. So community service is the new punishment given in BNS. So certain changes are brought in, so you have to go through the PDF also, because in BEAR Act you will not find those concept based things. Okay, it will be very difficult to read from BEAR Act. So I have compiled them and gave it to you. Okay, even now what I am talking in this thing is more of concept based than BEAR Act based. So BEAR Act is, as I told, it is maximum practice. I cannot teach you BEAR Act. Okay, so BEAR Act is practice. So, but you should know where that particular section lies, how to search that section in BEAR Act. That we will get in practice after 10 days, 12 days, or 15 days after, once we complete concept-based subjects, then we go to pure BEAR Acts. Okay, some things we cannot, I mean, there are a lot of other things also where we cannot learn through BEAR Act, but it is meaningless to continue to study so much big concepts. So we'll focus on the major subjects where there is high weightage. Say there are, how many subjects are there? 6 to 7 subjects are there where the weightage is more than 6 marks. Okay, or 4 marks. So we'll focus on that 6 to 8 subjects where there is more weightage. Then other things we will learn through BEAR Acts only. While we are solving the question papers, we will understand that subject. Okay. So what is crime? So Penal Act deals with crime. Okay. Indian Penal Code or Bharatiya Nyaya Sanhita, it is a penal crime. Okay, penal code. IPC, Indian Penal Code. So Nyaya Sanhita is also a penal code. Okay. So what does it deal? It deals with crimes. So we should know what is crime. Okay, but nowhere in penal code, BNS or BNS or IPC, nowhere they have defined crime. So they call it offense. So crime is not given anywhere. So instead of crime, they use the word offense. So offense is defined. Crime is not defined. So offense and crime, you take it as same. But since it is dealing with crime, because entire thing is crime only, we are talking about criminal law. Basically, it is called criminal law. But definition is not given about crime in IPC. Okay. So that is the only thing. So you have to relate it as an offense, and crime is one and same. When we are talking, if I say offense is same, crime is also same. So when there is a question, crime, don't get confused. It is offense only. Okay. So in BNS or IPC, they use it as offense. But in question paper, they may ask about crime. Okay. So crime is same thing as offense as per act. Okay. Crime is an unlawful act or omission which is punishable under the Bharatiya Nyaya Sanhita. Okay. An act or omission. So try to understand this thing. Act or omission. So act means you are doing something, wrong thing, unlawful thing. Omission, you are not doing something. If you are not doing something also, sometimes it is punishable. Okay. what you are not doing, anything you are supposed to do legally, you are not doing, you are not fulfilling that particular thing. So we'll learn over the period about those particular crimes. So not doing something which you are supposed to do or is also a crime. Okay. So crime is a wrong against society and not merely against an individual. See, try to remember this thing importantly, because if you are going for practice also, these things are important. Crime is wrong against society, not individual. So if there is something happen to any individual, that individual or any person can go and complain in the police station. I told you when we are dealing with CRPC, any person can go and complain, because crime is against society. Unlike civil law, if something happens to me, I had to go and do that. That is locus standi. Even for some constitution-based questions also, locus standi is there, except for public interest litigations. Okay. So locus standi is a must for civil cases. But in crime, any public can go and report it in the police station. And once the FIR is prepared, it is public prosecutor or police or the state who will run the case, not a private individual. Private individual, except in private complaints, like couple of private complaints are there, so like 1 or 2 cheating cases are there, and where a private complaint is there, and check bounce cases, small minor cases, those things, private complaint will continue, defamation sort of thing. Okay. But in maximum other places, it is police or state who will be running the case. Okay. And the other thing is, see, you want to withdraw also, police will not allow to withdraw the case. You can become, you can withdraw from it, but police will continue the case. You will be called as a hostile, okay, hostile witness or hostile evidence, whatever it is. You are going against, you may become hostile, but state will continue the case. If they file the charge sheet, they have to go ahead. If they don't file charge sheet, then they may dilute it and they may do something. But once the case trial begins, so police cannot, if you want to withdraw also, you cannot withdraw except if it is compoundable with the permission of the court, with going to Lok Adalat or any other process legally. The due process you can follow, that is compoundable crimes, which the list is given in the CRPC also, which crimes are compoundable. So IPC crimes only, those crimes are IPC, those sections you can compromise with the permission of the court. Okay, or you can compromise, but that is through legal process only. Okay. So theft, murder, cheating, rape, all those things are examples of the crime. Okay. Nature of crime. Okay, I'm talking about the concept. This is very important for you to understand. See, what is nature of crime? Okay, nature of crime is, it is a public wrong. It is moral and legal wrong also. Some moral wrongs are also ethical, and other wrong is also. And crimes are punishable by state, not individual. Crime is punishable by individual. Measured by intention. You see, mens rea is another concept you have to remember. Mens rea, guilty mind. This is very important. This is a concept. Mens rea is guilty mind. Remember this thing. So mens rea is very important in the crime. So intention is very important. So if it doesn't mean that if there is no intention, you are not punishable. There are certain crimes where intention is also not mandatory. But for most of the crimes and the intensity, the punishment, if there is no mens rea, the punishment is also reduced in some crimes. Okay. So this is under BNS, replacing IPC. Okay. About this BNS. Okay. And elements of crime. This this is another important thing. Elements. What is element? What are included in crime? What is the important thing? So human being is important. So the crime must have been committed by a human being. Okay. Normally the wrongdoer and the aggrieved both should be human beings, but since there are certain exceptions like animals, if you kill some animal illegally, then they'll be treated as crime. But normally the accused will be human being only, normally. So human being is the important element in any crime. Okay. Actus reus. Actus reus means act or omission. I told you, remember, even an act or omission, both are called actus reus. So if you are doing something, you should do that act. Without doing an act, it is not a punishment. If you think that you want to commit a theft, it is not a crime. You have to act and you do that work, then only it is a crime. You have to complete that act. Okay. So just thinking, having a thought of doing something wrong is not a crime. Okay. Mens rea. Mens rea is guilty mind. So this is very important. Intention to do something should be there. That is mental element. Okay, this is major fundamental principle of in criminal for determining the punishment. Okay, in criminal act, it is a major principle for determining the punishment. What is the mental state of the human being? See, human being who commissioned, that is actus reus, who commissioned that, and what is the injury? So there should be an injury also. Okay, so there should be an injury. Harm should be caused to some person, property, or society at large. There is a death, loss, or somebody you have threatened, whatever it is, fear, you caused a fear. All these things are mental injury or physical injury. It can be anything. Don't take it as only physical injury. Even mental injury is also threatening some person is a crime. Okay, so these are all major elements in any crime. Okay, so mens rea is important, actus reus is important, injury is important, human being is important, and it should be prohibited by law. Any act which is prohibited by law is a crime. Okay, that is one of the thing. Okay. And what are the stages of any crime? Okay, so first there should be an intention. This is the first stage. Okay, so criminal intention means the purpose of doing any act. Okay, by the criminal, I mean forbidden by any law. Okay, criminal law, what we have done in before this step, it should be forbidden by law. So that your intention is to do some wrong act, that is guilty mind, and it is prohibited by the law. Okay, then preparation. So you have to prepare for commissioning of that crime, like you are arranging some, purchasing some guns, here poison, if you want to kill by poisoning somebody. Okay, preparing a group where you want to do dacoity. Okay, or wage war against some country, Naxalites or terrorists are there. Okay, there is separate law, of course, but then counterfeit currency, making a group to prepare printing currency, distribution of currency, then bringing back the cash, all those, there will be a very big team effort. So all this preparation to arranging all the means. Okay, then attempt. So actual attempt that you are trying to attempt. Commission is completion of the crime. You are making an attempt, but if you fail, even in failing also, it is punishable. Okay, attempt is also punishable. Commission is attracts severe punishment. Say attempt to murder is there, murder is there. So murder is severe, punishment is severe. Attempt to murder is less severe punishment. Okay, so attempt is there. Then commissioning of the crime, that entire crime is completed. Last stage, that crime is completed. Attempt, first there is an intention, that is guilty mind, preparation, attempt, that is actus reus, then commission, that you have accomplished the crime. So these are the 4 stages of any crime. So this is the last stage. Once the accused is successful in his attempt, okay, that is the 3rd stage. If A fires, there is an example, A fires at B with an intent to kill him. If B dies, A is guilty of murder. If B is injured, guilty of attempt to murder. Okay, attempt to murder. So buying the gun is preparation. So intention to kill is mens rea. In this example, you got it, right? A fires at B with an intention to kill him. Intention to kill is guilty mind, mens rea. Firing is actus reus. Okay, buying the gun and bullets is preparation. Shooting is attempt. If that person dies, crime is accomplished. If he doesn't die, attempt to murder. That is attempt. It is stage is not completed, but still it is punishable because there is a serious attempt is made. Okay, so these are the stages in any crime, commission of any crime. So general exceptions is very important chapter. We'll talk about general exceptions later. So I'll give brief about punishments. Okay, so punishment, there are a lot of theories in punishment. They may ask question or they may not ask question, but I don't know. But they may ask some question. You will not find this punishment related question in barracks. Okay, deterrent theory, retributive theory, preventive, reformative, those things you studied in your LLB, right? When you are reading this criminal law, there is a subject called criminal law. In the criminal law, punishment, theories of punishment is there. Okay, so punishment is given by the state. Remember this, punishment is given by the state. Okay, so it can be on property, like seizing the property on the person, like putting him in the jail or whatever it is. Different types of punishments are there. So theories of punishments are there. Deterrent theory, retributive theory, preventive theory, reformative theory, and another, I think, expiatory or some whatever it is. There is one another. Just 1 minute. I'll just check this and tell you. Yeah, expiatory theory. Okay, so these, they may ask what is say reformative theory. Okay, they may ask. So they will give you an example explanation. This is reformative theory or deterrent theory or retributive theory or expiatory theory. They may ask, giving that explanation, they may ask you about you have to choose that under which theory it will come, that particular punishment. So this is very important. It will be there in your law books, but anyhow, I'll give you a small, just I have anyhow opened this one. I'll describe this one. So deterrent theory. So the term deter means to abstain from doing an act. The theory says that punishment is a warning to others. So the main object of punishment, according to this theory, is to deter. Deter means prevent, to prevent crimes. Okay, it is a warning to the offenders. So people are afraid. Okay, so I'll get this punishment, so I should not do this punishment. So that is determent. So deter. So deter is to prevent or to create a fear in the offender so that they will not do crimes. So deterrent theory. Okay, then retributive theory. So retributive theory is to give return. So you are returning. So repaying or punishing suitably. So what is the punishment according to that particular crime? So you are returning that one. So the idea of taking revenge against the wrong there, basically this is followed in some countries where eye for eye, hand for hand, something like that. Okay, in King's period, there was more retributive theory, and even in some countries still they follow that if somebody takes away eye, they will take away their eye. Because of some accident also, you because of you somebody loses an eye, then they will see to that they will punish you by taking away your eye. So that is old theory was there. So that is retributive theory. Okay, it is basically in tribal acts previous, and some old kings, they used to follow that. Modern criminal law, there is not there, but in some few, 1 or 2 countries, they may be following this, 1 or 2 instances. Okay. It is called kisa also in some Mohammedan criminal law. Okay, Muslim law, Sharia law, they call kisas. K-I-S-A, kisa. Q-I-S-A also they call it. Kisas, they may ask this kisa, you note it down. Q-I-S-A if you are having a kisa. Okay. It is punishment is also called retributive. Retributive theory is also called kisa. Okay, in ancient Muslim law, basically. Okay, and it is also followed in some old tribal
Repeat,
times.
sir.
QISA,
Yes,
or
sir.
you can call it KISA, kisa.
Okay, sir.
Okay, it is pronounced as kisa. Kisa is one retributive theory. Okay, the other thing is preventive theory. So the main, see, modern is a preventive and reformative theory. Okay, the modern criminal law, most of the criminal law is preventive and reformative. Whatever the punishment that they are giving is to prevent criminal from committing crimes. Okay, to keep him away from crime. So they will put him in jail so that he will not commit crimes. Okay, repetition is not there. So he will be sent away from the town. Okay, sometimes severe punishments like death penalty is there, life imprisonment is given. So that is preventive theory. Okay, so they will prevent instead of reforming him. But for small crimes, it is called reformative theory, where they will punish, give small punishment so that he will become a regular person and come into the society back. Okay, so they will give a punishment, say 3 years, 5 years, and they feel that he will improve and he will become a normal person so that he can come back and live his regular thing. He will become the regular part of the society. So that is reformative theory. Reformative theory aims at reforming a person. Preventive theory aims at the person, stopping that person from doing the crime. Okay, reformative is to bring change in that person. So they will punish him, but punishment is not death penalty or life imprisonment in those reformative. So the that punishment will be smaller punishment so that he will come back to the society as a normal person. So there is another expiatory theory. So this is expiatory theory means here the wrongdoer is forgiven. Okay, so if something happened to some individual, he can forgive him. Okay, so or he can do some penance. So they can do some fasting. See in 6. You remember there was a president called Gyani Jail Singh. Okay, Gyani Jail Singh, he was president from 1982, 84, 85, don't remember exactly. 1979, 1982, 85 or 1981 to 86, he was president of India. Okay, so during the time there was a Operation Blue Star is conducted. Okay, Operation Blue Star, because he is a Sikh. Operation Blue Star is the operation where they want to flush out terrorists who are hiding in Golden Temple in Amritsar. So Indian military attacked Golden Temple to flush out the militants. Lot of damage happened to the temple. So that is, he is the president, head of the state. Under him that happened. So he felt bad. So for that one, okay, for that reason,
he cleaned the
went
shoes
there
and all.
Huh?
He was cleaned all the shoes of the people
Yes,
who
of
visited
the
them.
people who visited the temple 1 day or 1 hour, 2 hours, I don't remember. But he sat there and he cleaned the shoes of the visitors to the temple. So that is expiatory theory. I mean, you do something for your own, or somebody will excuse you also. Okay, excuse or some own punishment sort of thing is expiatory theory. You do on your own. You got it?
Yes, sir, got it. Thank you.
Okay. Then another is kinds of punishment. Okay, as I told, there is one punishment called kisa. Then there is diya is there. Kisa I told. Okay, diya is blood money. So you kill somebody, you can pay money and you can come out. That is diya. That is also old way. Some Muslim countries even now they follow that. Okay, the family can take that money and excuse that person.
Still GCC is there, sir.
Yeah, okay, that is there. Then there is another thing called had. HADD had. So there is a punishment, a specific punishment. So more or less is not given. That specific punishment is given. Okay, like for particular thing, death by stoning, for theft or amputation of hands, those things are given. It is given. So judge cannot discriminate. So if there is a theft, the punishment is already described. So judge is not having any power to change the punishment. Small theft, big theft. There is a theft, then his hand should be cut. Okay. If there is a rape, he should be stoned to death. Example, just I'm giving example. So basically like in some countries or olden days, if women are having illicit affairs, basically illicit relationship, they used to bring in the public and they used to throw stones at her and kill her. Okay, basically they used to do to women, not gents in those days. So that is had. Okay, for illicit relationship, they used to kill through stones or cutting hands, because if that is proven, judge is not having any alternative. That punishment should be given. Okay. Then there is another thing called tazir. So here judge is having discretion. He will give whatever punishment he likes. He can just say that, okay, you are excused, you can go because of some compulsions, this happened. So you can go, because you are hungry, you committed a theft. So because of somebody very bad situation, you have committed a theft, so they can leave him. The situation based, the judge can have the discretion. Okay, you go to jail for 10 days and okay. But under HUD, even if it is small crime, even if you do it for emergencies, your hands will be cut off. If the punishment is for theft, it is cutting off your hands, then they will do that. There is no excuse. In Tazir, judge is having the discretion. Okay. So then there are punishments in Indian Penal Code, like death penalty is there, life imprisonment is there. Again, imprisonment, there is rigorous imprisonment is there, simple imprisonment is there. Then forfeiture of property is there, fine is there. Then ultimately, under new act, community service is there. Okay.
Sir, how many punishment are there, sir? Just like Hadd, Tazir and Kiss. Like
Tazir,
that, how many?
Kisa, Diya, Hadd, Tazir.
Sir, 1 second, slowly, sir, so that I can write.
Kisa, K-I-S-A, Kisa, Q-I-S-A also. Kisa, K-I-S-A or Q-I-S-A.
Okay.
Okay.
Sir.
Then Diya. Diya is, offender is giving money from exemption of liability.
Okay, sir.
Okay. Kisa is the relatives, or say if you kill somebody, his son can kill you. That is the Kisa, basically. Blood for blood, eye for eye. I mean, somebody has taken away eye, so their family members or the state can take away the eye. That is the punishment through Kisa. Same punishment. Okay. Whatever the loss you have caused, same punishment will be given under Kisa. It can be through state or it can be through the family member also. Injured person, relations or family member, they can do that. Okay. Diya is blood money. Okay. Diya is blood money. D-I-Y-A Diya or D-I-Y-A-T also they call sometimes. Okay, it is blood money. So the offender, instead of punishment, taking the punishment, he will give money.
Diya. Okay, sir.
Okay. Then the family members, they will accept that money and excuse this person. Okay. Then Hadd, H-A-D-D, Hadd. Hadd is the limit, boundary. Hadd ante boundary. Haddulu antam kada. Hadd, H-A-D-D, Hadd means boundary or limit. So here, judge is not having any discretion to give punishment. Already punishment is defined. So for this particular act, this is a punishment. For this particular act, this is a punishment. So that is Hadd. So even if the judge feels that it is a severe punishment, there is no exception. They have to give that punishment.
Okay.
Then there is Tazir.
Tazir.
Yeah. So here judge is having discretion. He can give small punishment or big punishment depending on the situation. So that person has committed a theft because he was very hungry. So he will say, okay, you stay in jail for 1 day and go. Something like that. Instead of cutting away hands, even for because of hungry, he had just stolen a small bread piece. Even if he steal a bread piece also, under had his hands are cut. Okay. So under Qazir, it is judge. He can say you are in jail for 1 month, you are in jail for 1 year, or you are in jail for 1 day. The judge is having the discretion. Okay.
Yes, sir.
1 minute, I just hold on. Okay, I'll take the call later. So that is the thing. Okay, these and there are 6 punishments under Indian Penal Code BNS, 5 punishments under IPC, 6 under BNS. So death penalty is there, life imprisonment is there. Imprisonment, there are 2 types of imprisonment: rigorous imprisonment, simple imprisonment is there. Forfeiture of property is there, fine is there, and community service is the new added under BNS. Okay, so they may give you option. Okay, which are under IPC, which punishment is not there. So they may give death penalty, rigorous imprisonment, fine, community service. So this option may be given. So community service, which is not there in IPC. Okay, you should read question carefully. When you are answering the questions, you should read that carefully, because that is very important. Not is there, yes is there, no is there. Those things are very important. So we will be confused sometimes. So we will write wrong answer. So just be careful when you are, so which is not there in IPC. In IPC, community service is not there. Okay. And this general exceptions is very important chapter. Okay, so you will get 1 or 2 questions from general exceptions. So general exceptions means there are certain circumstances under which an act that appears to be a crime is not punishable. Okay, because mens rea is not there, or some other reason is not there here. Okay, general exceptions is that. Accident. So you killed a person in an accident because you don't have that intention. That is, mens rea is not there. So that is an exception. Because of you, somebody died, but since there is no mens rea, you may be excused. Okay. So general exceptions is there, a very big chapter around, so 25-30 sections are there. So you can go through that sections in the BEAR Act itself. In IPC it is there, BNS also is there. We'll some section 14 to 30 of BNS cover this and section. See, in IPC there are 30 sections, but in BNS it is only 16 sections or 17 sections in BNS. So they have combined couple of sections in BNS. So 14 to 30 under BNS and 76 to 106 in IPC are general exceptions. Okay, so that is basically general exceptions is more focused on guilty men. Mens rea, that's what I was telling. Mens rea is very important when you are practicing criminal law or when you are doing some criminal practice. Punishments, when you can prove that there is no mens rea, also your client is excused in many cases. Okay, if you prove that he is not well, his mental state was not well, or he is a minor, or he is intoxicated, or he is done ignorantly or accident, whatever it is, mens rea is not there. Then self-defense is another one of the mens rea. Okay, self-defense, you are trying to protect yourself or your known person, some serious attempt is happening, then also it is excused. So those things are, because there was no intention for you to attack or harm that other person. Because of your self-defense, you harmed that person. So there is no mens rea. Because your intention was not there when you are doing that act. So that is general exceptions. So this is a list. Mistake of fact, not law. A mistake of law is not an exception. So judicial act is also is exception. Like some judge is punishing, police is doing under these things. Okay, under judicial act is committing something, then it is not a crime. Exception is there. Accident, absence of criminal intent, consent of the person. There are certain crimes where the consent is given. Okay, in some sports games, something you give a consent, right? To you are ready to take that risk. In some risky games are there. Okay, communication made in good faith, acts done in compulsion, private defense. So those things, exceptions are there. You can go through the Bail Act, okay, so that you can, in private defense actually it is very big section. 6 sections are there for private defense. Okay. So actus non facit reum nisi mens it rea. So see, you try to remember this thing. Actus non facit reum nisi mens sit rea. I'll share this one also. So this is actus reus, okay? This is related. The act done alone does not make one guilty unless the mind is also guilty. Okay, mens rea is given. So try to, because this is some Latin words. So act not facit reum nisi mens set sit rea. Okay, I cannot understand this. So, but since translation is given next to that, I am trying to read that. So act done alone does not make one guilty unless the mind is also guilty. Mens rea is guilty mind. So just remember mens rea is guilty mind. So this definition they may ask. What is act non facit reum nisi mens recit rea? So mens rea is guilty mind is not there. So that act committed without guilty mind is not guilty unless he is having guilty mind. So just keep this in mind. Okay. So this is the thing. You try to go through the Bail Act. If there is anything questions, because I thought I'll do this thing just anyhow, I'll go through the Bail Act also chapter wise. General exceptions is very important. Okay. See, new chapter offenses against women and child. This is a new chapter added in. There is no specific chapter for offenses against women and child. It was scattered earlier, so it was made a separate chapter, and all laws are sections earlier. Even though if some sections were there, so they brought it here. I knew 1 or 2 new things are also added here. So 1 or 2 sections are also removed. Okay, so offenses of marriage, all those things, dowry, death, everything are brought under this thing. So you may expect some questions under this chapter also. Chapter 5, I'm talking about BNS. Okay. So if you are carrying that one, you keep it, or you can note down chapter 5, offense against women. So that is there. General exceptions, that is chapter 3. Okay. So definitions they may ask. Definitions are all under section 2. See, the advantage in definitions are given in alphabetical order. Okay, definitions are given in alphabetical order. If something is asked from definition, even though if it is from IPC, you can try to search in BNS and you go and relate it to IPC. Okay, because IPC, they may be some order may not be there, but there also maximum definitions are in order only. So it starts from, see, if you go to the definition, act, animal, child, counterfeit, court, death, dishonesty, document. So all those things are in alphabetical order. Life, local law, man, month, movable property, number, oath, offense, omission, person, public. So what is person? They may ask. So you can straight away go to section 2 and go alphabetically, you will find the person. Okay. So that is the public servant, section 2 bracket 28. 2 bracket 28, that is under there. So there are illustrations also in the sections in between. In IPC, you will find lot of illustrations. So just go through that Bail Act at least once or twice. Try to browse faster, so you will understand. Okay, and when we are doing the question paper, solving question papers, we will understand how to look at these illustrations. Okay, so they will give you an illustration. They will say from which section it is. So when they give some illustration, to check whether which section it belongs or what exactly it is, you go reverse. Go to that section, check whether that illustration is there in that section or not. Go to next section. See, they have given 4 sections. Go to that section, check all the illustrations under that section. Some sections don't have illustrations also. So if out of 4 sections they have given, only 1 section is having illustrations, you are saying that just go through that one. If that is there, you can write that answer. If there are only 2 sections where illustrations are given, you just go through those 2 sections only. See, illustration, sometimes there will be very huge illustration, 4 or 5 illustrations are there. It will take 1 or 2 minutes also sometimes for reading all the illustrations. For if illustrations are there for all the 4 sections, it will take 3 minutes for you to answer that, because you have to go through all those things. Luckily, if you find that in the first section itself, you are saved. Don't go to second, third sections. It will be standard wordings. There won't be any change in the wordings. So if you are carrying, anybody is carrying your Bear Act in your hand. So if you are carrying Bear Act, you can go to the illustration. Say, I'm talking about section 2(8) document. There is an illustration 1, example illustration 1. It is immaterial by what means or upon what substance the letters, figures, or marks are formed, or whether the evidence is intended for or may be used in a court or not. You don't know what exactly section it is. Okay, just it is immaterial by what means or upon what substance the letters, figures, or marks are formed, or whether the evidence is intended for or may be used in court or not. That illustration is given, and they asked under which section it will come, or what is this? It is a document, or it is a court, or it is a death, or it is dishonesty. What is this? So you should know where document is there. Or if they have given the section, it is much easier. If the section is not given, so you should know that document will be there in the definitions. Punishment is there in the definitions. So you can just go to that. That is the reason I told you should understand some concepts. Okay, just go to that one. Section is there. It is much easy. If section is given, in 90% of the cases, section will be given. Just go to section 2(8) document. Just read that illustration. Okay, it is there in the first point. Just don't go to anything. It is word to word. Illustration will be there. Won't be even change in the names also most of the time. A writing expressing the terms of a contract. They will use the A expressing the terms of contract. Sometimes they will use Ram expressing the writing expressing the terms of contract. They may use Raju expressing the terms of contract. They may use that, but normally they will use the same wordings also. And in every book, whatever Bear Act you buy, it will be A writing expressing the terms of contract is only used. Okay. In illustrations, wording is used in the same manner in all books. So just go there. See, in this document, there are, how many illustrations are there? 3. 3 illustrations are given. Okay. And in 3 illustrations, there is explanation, there is example, some small other things are given. In illustration 2, there are 5 examples are given. In illustration 2, there are 5, this thing is given. Okay. So, you can go through that one. Okay. That is important. Once you find where exactly that is there, you can straight away answer that one. A power of attorney is a document. Illustration. Okay. So they may ask such question, wonder what section is there, 2A, 2B, 2C, 2D, or this is section 2 under bracket 8. So such questions are also asked. So illustrations are very important. Maximum illustrations are there in IPC. So you can expect 1 or 2 questions from illustrations also. So you will understand that when you are practicing. That is the reason I told you to practice 10 question papers at least twice. Once when you are practicing, you make a notes. Once you complete the practicing for the first time, don't second time when you are answering, you have to complete that it in 3 hours. Okay. So you have to complete that in 3 hours. That is very important. Okay. So I am stopping the recording 1 minute.